Get ready for the dictation. Start. The petitioner has preferred this petition against the order passed by the court below, rejecting the application for extension of time for depositing 20% amount as per section 148 of the Negotiable Instruments Act 2018. Learned Counsel submits that the petitioner was asked to deposit 20% of the amount within 2 months wide order dated 8th May 2019. However, the petitioner met with an accident and therefore he could not comply with the order dated 8th May 2019 and presented on 17/9/2019 himself before the court along with a draft of amount 20%, that is rupees 2,80,000. However, the court refused to accept the draft and directed him to deposit the amount in cash and listed the case on 23rd September 2019. The petitioner brought the amount in cash on the date fixed, but it was refused by the concerned court on the ground that the period prescribed in the Limitation Act has expired and observed that only the appellate court can extend the time. He therefore filed an appeal for seeking extension of time, which was rejected by the Additional Session Judge number 2 Alvar Wide order dated 24/9/2019 on the ground that the period provided under section 148 after the amendment made in 2018 is 60 days can be extended by another 30 days, and as 90 days period expired on 8/8/2019, therefore time cannot be granted. Stop. Learned Counsel relies on the judgment passed by the High Court of Punjab and Haryana at Chandigarh in the case of Baljinder Singh versus Harpinder Kaur CRM 54105/2019 dated 10/1/2020, wherein 60 days time was further granted by the court in exercise of power under section 482 CRPC. I have considered the submissions. Section 148 was inserted wide amendment dated 16/8/2018. That apart, section 143A was also inserted by aforesaid amendment act for the disposal of the case. It would be appropriate to quote the provisions of section 143A and 148, which read as under. In the Negotiable Instruments Act 1881, hereinafter referred to as the Principal Act, after section 143, the following section shall be inserted, namely 143A, power to direct interim compensation, notwithstanding anything contained in the Code of Criminal Procedure 1973, the court trying an offence under section 138 may order the drawer of the check to pay interim compensation to the complainant in a summary trial or a summons case where he pleads not guilty to the accusation made in the complaint, and in any other case upon framing of charge, the interim compensation under subsection 1 shall not exceed 20% of the amount of the check. The interim compensation shall be paid within 60 days from the date of the order under subsection 1 or within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the drawer of the check. If the drawer of the check is acquitted, the court shall direct the complaint to repay to the drawer the amount of interim compensation with interest at the bank rate as published by the Reserve Bank of India, prevalent at the beginning of the relevant financial year within 60 days from the date of the order, or within such further period not exceeding 30 days as may be directed by the court on sufficient cause being shown by the complaint. The interim compensation payable under this section may be recovered as if it were a fine under section 421 of the Code of Criminal Procedure 1973. The amount of fine imposed under section 138 or the amount of compensation awarded under section 357 of the Code of Criminal Procedure 1973 shall be reduced by the amount paid or recovered as interim compensation under this section. Stop.